Testing. Is that what they do? Hello. Sound check. Does this have a volume now?
That's the volume's up all the way on that.
Okay. All right. Well, I'll just have to make sure it's close by.
I'll see. Not you yet. You're not. I just want a sound check. So you don't okay, let me do it. Mike, can you hear okay back there? Okay. If anybody cannot hear, just raise your hand during the speeches and we'll try to talk closer to the mic.
Good morning. I'm delighted that you all were brave enough to come out in this spitting rain when a half an hour ago we all thought we were going to be heading for the bomb shelters under our houses. So have a seat, and I'll just speak for a minute. I was just walking by Bruce his red book. I'm assuming you all have a red book? Okay. In that book somewhere, there's something that says something like items you might purchase. And I was doing some sorting out of paperwork of my own at home and realized that I needed to get rid of the ID information on prescription bottles that I was dumping. And you probably all had that happen. Do you soak them? Do you scratch them out with a knife? What do you do with them? There's a couple of products I just want you to be mindful of. One, the Legacy team all got this. It's called Guard Your ID Plus. And this is a roller that has all kinds of funny grids on it, so it really wipes out all the information. So this is important because at some point, if any of you end up being a POA or an executor, there's tons of paperwork beyond your imagination. And if you don't have a shredder or you don't want to destroy your shredder, this can block out a lot of the information. You can buy these online, $8 or $10. I've found it immensely useful. An alternative, not quite as secure, but less expensive, is a Sharpie. We all have Sharpies, right? Not the skinny one. This is called king size. So the king size Sharpie, if you probably wail away at it, you're going to soak right through the paper, so that the key information that you want to obliterate will be gone. So it is on your list, but it's something you don't need to wait until you're a POA or executor. It may be something right now you start thinking about documents, as I said, prescription bottles that you're tossing, and you don't want to have to soak them. That's what my husband used to do. I used to take like a sharp knife and scratch it all up. That was a nuisance. These are much easier alternatives. So, having said that, yes?
Tell them to save one if they start with the prescription bottle. Save one, and we'll talk about it next week.
Okay, if you have one empty prescription bottle, it can be any size, doesn't need to be huge. We have a new piece of paper. See, this thing is evolving all the time. The more we think about it, the more we say, here's a remedy. And Julie's going to talk about that next week as to what goes in that. So save one, it can be small or big, small is probably better, empty prescription bottle, clean preferably. And we have a document that you can have in there in case of emergency. So we keep finding new things that we think would be useful for everybody. Okay, so I'm going to turn the program over to Betty, Betty Mann, and she's going to then turn it over to John. Thank you.
Welcome back to our Tending to Tomorrow series. Last Saturday, retired pastors Nan Dahlberg, Carl von Eigen, and Barbara Turner Delisle, right? Delisle, French, led a discussion about the conversation, how to begin the necessary talks with our loved ones on what our wishes are for the end of life or for the event of our incapacitation. Their combined many years of experience as pastors was evident in their understanding of the dynamics of these delicate conversations. Their presentation was very interesting and enlightening. Lori and Julie introduced the idea of having a red binder to accumulate all of our documents and plans in one very recognizable place to make it easier on whomever is responsible for carrying out our wishes. I was very happy that so many of you expressed the same enthusiasm for the Red Book as I felt when the idea was first suggested. Before I became involved with this team, I felt that I was in pretty good shape as far as my estate planning was concerned. Well, I realized I had overlooked many critical areas that needed to be addressed and written down. I have most of the documents someone would need in the case of my incapacitation or death, but someone would have to do quite a bit of searching to get it all together. And those specific details are the things you just don't want to address. Well, I really hadn't given those items serious thought. I guess as long as you don't get hit by a bus, I'm okay for a while until I get my Red Book completed. Speaking of getting hit by a bus, luckily 5 months ago, when my parked car was totaled by a drunk driver at 2 o'clock in the afternoon, I wasn't in it. While watching the accident scene, I'm thinking, wow, I really do need to get that book together. After our first planning session for this seminar, I was very excited about this gift that I could give to my children. I showed them the index to my Red Book, and they were very appreciative of the fact that I was getting this together for them. Our seminar today is about the legal issues involved and the legal documents that can make your estate plan run smoothly. We are very pleased to have a local Dunedin attorney here to discuss some of these issues with us. After he finishes his presentation, we'll leave some time for any questions you may have. John Freeborn is a native of Clearwater and grew up in Dunedin. He is a graduate of Haverford College, Haverford, PA, and the Tulane University School of Law in New Orleans, where he received a JD with honors, and also the New York University School of Law with an LLM, or Master of Law in Taxation. He is licensed in Florida and New York. He practiced in the Trust and Estates Department of a New York law firm before returning to Dunedin in 1992 to join his father's practice. His father practiced law in Dunedin from 1957 until his death in 2008. John's sister, Allison, is also licensed to practice here in Florida, and she's also licensed in Illinois, and they have their firm downtown Dunedin called Freeborn and Freeborn. John is board certified in wills, trusts, and estates. He's a member of the Florida Bar, the Clearwater Bar, and was chair of the Clearwater Bar Probate and Guardianship Law Committee for 2009 and 2010. He has served on several boards in Pinellas County, including the Planned Giving Advisory Council for Morton Plant Meese Healthcare Foundation, the Dunedin Rotary Club Foundation, the Pinellas County Estate Planning Council, the Community Redevelopment Agency Advisory Committee for the City of Dunedin, and the Dunedin Fine Arts Center. He is past president of the Dunedin Rotary Club and also served on the board of Meese Life. It is my pleasure to introduce John Freeborn.
Thank you, Betty, for that introduction. It was quite long, but it sounded better than I thought. So anyway, I don't enjoy public speaking or do it very often, and nobody but Betty Mann, I think, could talk me into it. I've known Betty and Dan for many years. We've sort of worked in related fields. She worked for a local CPA company that I had a lot of mutual clients with. And Dan was at SunTrust Bank, which is across the street from our office. And so actually, my dad had worked at SunTrust Bank in the trust department many, many years before. So it was sort of our go-to bank. So anyway. Pick it up? Is that any better? Yeah. Yeah, okay. Well, it doesn't get, unfortunately, there's a piece of wood here that's, let's try that one. Okay, I'll just be a little askew here. So anyway, and it sounds like the first presentation that you have is the most important one that you can have, because I always emphasize that the legal documents are very important, but having a frank discussion and actually talking about these things is what makes it all work. If the first time that your family or children or whoever it might be find out about your estate plan is when they're at the funeral or afterwards, it doesn't always work as well. So, the estate planning is an area that involves planning for both financial issues and healthcare issues, and it's for both during life and after death. There's a related area called elder law, and that we're not going to be discussing today, but that's sort of involving the methods of funding for long-term custodial care, skilled nursing facilities. We're going to be doing mostly estate planning. And another area that's becoming extremely important, and it's really the only thing that's changed dramatically in the last few years, is dealing with electronic assets and accounts. And I understand that you're having a speaker next week that will be discussing that, and so I'm going to shy away from that. But that is very important. In the old days, we would just get the mail forwarded to the office, and eventually you might find an asset that you did not know about. But if people signed up for electronic statements or whatever, you'll never know. So, and I saw part of your red book involves having passwords and PINs and all that. So anyway, let's see. Let's start on the financial side. Most people have heard of wills. These documents deal with where your property will be distributed upon your death and who will be in charge of that distribution. Since a will only takes effect at death, it's important to have another document, which is called the durable power of attorney, to deal with property prior to your death, but when you can no longer handle it yourself. If you only have a will and no power of attorney and you become disabled, which is more common than you think, everybody hopes to drop dead on the golf course, but they don't always. So sometimes they linger, and you have to figure out how to handle things. And in that case, you might end up in a guardianship, and a guardianship is something that most people don't want to be involved in. It's important to understand that a will only covers property that is in the individual or sole name of a deceased person. That just says Betty Mann. Doesn't say Betty Mann or. There are many other ownership designations that do not pass under the terms of the will, and those would be joint property, payable on death, transfer on death property, beneficiary designations. Most 401ks, 403bs, IRAs, insurance policies, and annuities have beneficiaries named on those. So those will not be governed by the will. And a common misconception out there is that the will is the controlling instrument over whatever beneficiary designation you might have, but it's actually the opposite. What the beneficiary designation says is what will happen regardless of what is in your will. So I think Betty mentioned, first to die, second to die. That's why with a married couple, when the first spouse dies, there's usually not that much to do because, majority of people have things joint or have their spouse as the primary beneficiary. So it's on the death of the second spouse that things can possibly get a little more hectic. But those kind of items pass to the designated beneficiary usually with just a copy of the death certificate, and they don't have any kind of court involvement or probate administration. The other thing that I've found that a lot of people believe is that just having a will says where your property goes. The will's like the direction, but until it's activated, nothing happens. So you can't just show up with a copy of your will at Bank of America and it says, see, here it goes to so-and-so, and they'll do it. They're like, no, we want to make sure that on Monday your son doesn't come and say, Mom left everything to me, and on Tuesday your daughter comes and says that. They want something that's appointed you. So something that appoints a person to be able to like manage that. Because the bank or the financial institution, they're not going to be, a lot of times they don't actually look at the contents of the will. They just want to know who do we take direction from. At the time of death, if you have a will and you have individually owned property, you have to file that with the court. And in Florida, we have circuit courts, and there's one for every county. We're in the Sixth Judicial Circuit, which covers Pinellas and Pasco counties. But even though it's the same circuit, they have different clerks in every county.
Try to raise this.
Okay. Thank you.
Welcome.
There's a different clerk in every county, and they do it their own way. So it's interesting, if you have one in Pasco County, you can be somewhat different. And we've recently gone to electronic filing. You don't have to go to the courthouse anymore. You file it, and they have a statewide portal for Florida, which is one place, the My Florida Courts, and you file all that there. But you find out very quickly that even though there's a statewide portal, every county is different. How they file it and all this stuff. So I had to file something in Bay County recently, which is in Panama City, and it's like completely different than Pinellas County. But anyway, so at the time of the death, you have to have the original will, the death certificate, and there's this thing called a petition for probate. And it says, this is the person who passed away, this is who they've appointed as beneficiaries, this is who they have as their personal representative, more about that later, and please appoint me. In Pinellas County, they always require a bond. There's only 2 counties in all of Florida that always require a bond from the personal representative, and it's Pinellas County and Broward County. All the other counties will discretionarily determine whether you need a bond. The bond is just to make sure that the fiduciary acts what they do, and if they don't, so that if they abscond with the estate assets, that there's some place that the beneficiaries can be made whole, or sort of whole. So anyway, so you file that, and then they issue something called letters of administration, which is a little piece of paper that has a little seal on it, and that's like your ticket to basically step into the shoes of the decedent and start acting as the personal representative. But the whole thing is you have to do something more to get appointed. The will on its own doesn't handle things. You probably heard of revocable living trusts, which is something that some people will do to avoid probate. And that sort of is a document that sort of takes care of itself. You don't have to go before anybody, any court or anything, and get it validated. So that's one of the reasons, and we'll get to that later, why people often choose a trust is that they don't have to bother with the court. We use the term personal representative. Everybody knows the term executor, but they are the same thing. Executor is the traditional term for the person, the fiduciary that handles the estate. But technically an executor under common law has to have a will. And if you die without a will, then you're an administrator. If you're a woman, you're an executrix. If you're two men, you're executors. If you're 2 women, you're executrices. And if there is a will, but you weren't the person named in it, you're an administrator CTA, which means cum testamento annexo. So in 1974, I believe it is, Florida said, we don't really care how you got to this job, will, no will, man, woman, whatever, you're all personal representatives. So those terms are interchangeable. Feel free to use the term executor. Everybody understands what you mean, but because that's more common. But Florida calls it a personal representative, or PR. So, and then the other thing is, if your assets are $75,000 or less that you're trying to collect, then you can do a thing called summary administration, which is a little easier. There's no bond, there's no publication. Summary administration. And the weird thing is, and we can talk about this a little later too, is homestead. Florida's unique in that it has this concept of homestead. Your primary residence is your homestead. Everybody knows about the fact that you get a tax exemption for it. And I believe, Bruce, you are a snowbird, so you've learned that Florida loves to figure out how to make other people pay for some of the things. So they give residents, if it's your primary residence, a $50,000 exemption on your taxes. Not $50,000 off the taxes, $50,000 off the value. And there's a thing called Save Our Homes Cap that says that the value of your home can't go up more than 3% or the inflation rate, which I guess now, for the first time in 30 years, could be more than 3%. It's always been 3%. So anyway, people that are not Florida residents don't get that, so they get to pay more for their same house. But the other thing, other than tax exemption, is that if you're survived by a spouse or minor child, you cannot leave that house to a minor child, and then while you're, anybody but the spouse or minor child. And then the other thing is your house is exempt from claims of creditors. Obviously, if you have a mortgage, you have signed a waiver to that because no bank would loan if they could never collect. But if you have no mortgage, they can't get at your homestead property. So that's how you can say, because you can say, well, John, who has $75,000 that owns a house? How can you ever use summary administration? If it's an exempt homestead that you're leaving to an heir at law, they don't count the value. So if it's a house plus one bank account, then you can sometimes get under that. And we'll talk about summary administration more. You can't deal with creditor problems with that. You have to open up a whole estate for that. So a will has a lot of flexibility. You know, you can have all sorts of provisions for gifts, including specific bequests of property. You can say, you know, I leave my car to so-and-so. I leave the sum of $10,000 to so-and-so. I leave my Picasso painting to so-and-so. But every will have what's called the residuary clause, which is a little further down. It says, all the rest, residue, remainder of my estate, wherever situated, I leave to so-and-so. And you can leave it to one person, you can leave it to all of my 3 children, you can leave it 50% to my friend and 25% to the SPCA, you know, that sort of thing. Because obviously your estate is a moving target, you know, particularly if you have stocks and bonds and whatever, you know, today it could be worth X dollars and tomorrow it'll be worth Y. The other thing is people could, you know, win the lottery, or you could be in an assisted living for a long time and spend all your money. So we don't know today. You can't like say, oh, I have $100,000, I'm gonna leave it this way. There's always you have that residuary clause to expand and contract depending on what your assets are. Yeah, percentages are good. Sometimes people will do like parts. I leave it in 8 parts and I leave 1 part to so-and-so. That's if you want to leave everybody equally. If you want to have people that are more, you know, then you do percentages. So anyway, you know, I did mention that word probate, the probate court, where you go to have your will validated. So most people have heard the term probate. It's a dreaded term. It's not a 4-letter word, but sometimes it is. Most people have heard of that and they've been told it is something they want to avoid. The reasons for wanting to avoid probate might be, first of all, it's a court procedure. So that means there's a filing fee. Usually it's about $500 filing fee. Because it's a court proceeding, you have to have an attorney. You can do a summary administration on your own, but you need to have an attorney for that. So you're going to pay an attorney to be doing things for you. You have to get a bond in Pinellas, a couple $100 there. You have to publish a notice to creditors. So there's another $100 or something. And there's a procedure. You know, there's the whole creditors thing, which is where you publish. So it used to be you could just publish a notice in one of these obscure legal newspapers that nobody has ever looked at, and said that, you know, Marge Brown is deceased. If you're a creditor of Marge, please come forward and call us. But there was a case, a Supreme Court case that came from Oklahoma that had a similar procedure that they have in Florida, and they basically said, if you have actual knowledge of a creditor, you have to give them actual notice. So if we open up, if we look at your stuff and we see that you have a Visa credit card, we have to actually write to them. We can't just hope that they don't see it in the paper. So anyway, so that's the whole creditor procedure. You have to notify them. They have a certain period of time with which to file a claim, and then you have a certain period of time, it's 3 months, from when you do the notice of administration. And then they have a period of time to file, 3 months, and then you have basically a month to object to it. And then they have a certain period of time with which, if you've objected but they think it's a valid claim, then they have to file what they call an independent action. They have to actually sue the estate in court. So, so that means you're not going to close up a probate estate in less than 6 months at least. So, in addition to, the possible expenses, there's the whole time thing. You're not going to get it done immediately, which does not mean that you can't make distributions to beneficiaries. It's not all or nothing. You can say, okay, we're writing you a check for $10,000 on account, and we'll settle up in the end. But you don't ever want to do all of that until you know that all the creditors are taken care of. So if you have less than $75,000, can do that summary administration, but you believe that there are unresolved creditors, you're going to have to open up an estate. So we'll talk about something that's near and dear to my heart. We talked about filing fees, but there are attorney fees. So, and the Florida statute is kind of weird. And there are also personal representative fees, the person that handles that. And I think that was one of the questions that you had addressed was, can the person that handles this, your executor, be paid? And yes. So the statute says that a personal representative is basically entitled, it's basically 3%. 3% on the first million or whatever. And I did bring my little book. If we have questions that we need specific answers, we can look it up. But when it gets over 3 million, then it goes down to 2.5%, then it goes to 2%. So, and the attorney gets a similar amount. It's basically the same thing, around 3%. But it's weird, on the first 100,000, they have stair steps for the attorney fee that they don't have for the PR fee. And I think that's an acknowledgement that even a $40,000 estate has a certain amount of things that they do. So it's, they charge X number, $1,500 on the first 40,000, then it's another $750 on the next 30, and another $750 on the next 30. So by the time you get to 100,000, it is still 3%. So, but the important thing to remember on all these things is that the root or the foundation of attorney fees and personal representative fees they're supposed to be reasonable. So that percentage is not a set percentage. The foundation is PR and attorney fees shall be reasonable compensation. And then they say, and this is what we presume to be reasonable compensation. So it can always be negotiated around. You could negotiate with the attorney for an hourly rate or whatever. It has to be reasonable. So, because there's all kinds of estates. You may have somebody that has one mobile home and one account at Bank of America. And that's not going to be as hard to do than the person who has, we don't see that now because interest rates are low, but we used to get it where the decedent had like CDs at every bank in town, and the other thing we don't see as much is most people now have brokerage accounts, so they don't even have the paper certificates. But if you have a $3 million estate and the brokerage account is 75 pages, that's going to be more complicated. So if it's a real easy estate, it's hard to say that reasonable compensation is a flat 3% as it goes on. The other thing is you have to look at the other end, not what the assets of the estate are, but who are the beneficiaries. If they've left everything to the SPCA, you're only dealing with one beneficiary, and that is easier than if they have 5 children, one of whom died leaving 3 children, and you're dealing with 8 people who love to call you constantly and find out what's going on with the estate, and that sort of thing. So that can make a difference. And then we'll talk about this further, but there is the thing called a federal estate tax. Luckily, the federal estate tax exemption is $12 million and change for each person. So we don't have to deal with that too often anymore. Back in the good old days when I started, the exemption was $600,000 per person, and we used to have to file Form 706s all the time. And now I haven't done one in 2 years. So anyway, so obviously an estate that has an estate tax return is going to take longer to administer too, because you have 9 months to file the estate tax return. The IRS, and you can extend it for 6 more months, so that could be 15 months. The IRS has 6 more months to accept or audit your return. So that's, you're talking pretty much 2 years at that point. But like I said, that's rare, and anybody that is afraid of that issue here, congratulations. Because, you know, it's basically $24 million for a married couple before you have to worry about taxes, so.
If you're in that group, leave some to the church.
Well, and the important thing to remember is a church or a charitable organization actually is a deduction off of your estate tax return. So if you had $50 million and you left, you know, $40 million to your church, you only have a $10 million taxable estate. So anyway, so it's, yeah, those are good things to do, certainly. Let's see. Oh, we're talking about reasons why you might not like probate. We talked about the expenses and the time that happens. The other thing is technically a court proceeding is public information. So your nosy neighbor could either look online or go down to the courthouse and see what you've done. Now you can't get a copy of the will from the online records, but you technically could drive yourself down to the courthouse in Clearwater and ask to see the file and see what is in the will. Most people's wills are not that interesting, you know. If somebody goes down and finds out that you left it to your spouse, and if your spouse didn't survive, you left it to your children, or whatever, that's not going to be shocking, but it is a public record. The inventory, however, is sealed. So you have to file an inventory on every estate within 60 days after opening it up, which just says, this is what I've found, and you can get extensions, but this is what I found that the decedent had. What? Oh, lean in. This is what the decedent had. So your nosy neighbor can't see that. That's actually sealed, and only the beneficiaries can see that. That's one of the things that people don't like. Anyway, so those are probably enough reasons for some people to do it. A trust. One of the things that people are sometimes under also a false assumption is that if you set up a trust, that it's you don't have to pay estate tax on it. It avoids creditors and that sort of thing. But a revocable trust, one that you can change frequently, is still part of your estate for creditors to come after. So the answer is no, it's not exempt. But as a practical matter, if you haven't filed something in court, it's a lot harder for creditors to find out who the right person to notify or that sort of thing. So it does save you a little. So what people will do is often they'll set up a revocable living trust during your lifetime. But you can do it. You can do it with payable on death and joint accounts as well. And I'm sure a lot of people here have POD. They sometimes call it, well, banks usually call it PODs. Brokers usually call it TODs, transfer on death. Sometimes you can do that, and that will solve your problem, and you don't need a trust. But if you have a more complicated family situation or a financial situation, you might want to set up a revocable living trust. interesting thing about why a revocable living trust works and is not assets in your own name is you do have to follow up, which is something that often gets left out, which is you go to the attorney or however you do it, you set up a trust, and then you put it in your red book, and you never do anything about it. So if you haven't gone to your banker or your financial advisor and say, hey, I have a trust now, and they say, oh, we need to change this account from the Betty Mann, where it just says Betty Mann, to the Betty Mann trust dated, October 15th, 2020. Because it has to be in the name, then it's not an individually owned asset, and then that's how you avoid the probate. So if you don't follow through, you haven't really saved yourself that much time or money, because everybody that has a revocable trust has a thing called a pour-over will, which is still a will, but it says where the residue is. Instead of saying I leave the rest residue remainder of my estate to so-and-so, it says I leave the rest residue remainder of my estate that might be to the currently acting trustee of my trust. So it's not the end of the world if you haven't done that legwork, but you will still have to open up some sort of probate to collect that. What did you call that? A pour-over will. Pour over, P-O-U-R, over. And sometimes I put a dash in and sometimes I don't. I don't know what the correct way is. The thing that I brushed upon homestead is one of those things that it technically is not a probate asset because it's defined under the Constitution. So I can tell you that if you just had payable on death accounts and a house that you left in your own name, that's not probate. But you still have to come to the attorney. The attorney has to file a thing called a petition to determine homestead. So you can say, if it looks like I'm filing something in court, that seems like probate to me, John. So, so generally, you can put your home in your trust. Usually you like to reserve a life estate so that you make sure that you don't mess up your homestead exemption for tax purposes. And there's another thing, I don't know if people, I seem to find more and more people have heard of this thing, which is called a ladybird deed. Okay. So anyway, that seems to be growing in popularity because it had been where you could put payable on death or beneficiary designations on bank accounts, but you still were stuck with the house. What do I do with the house? And a traditional life estate where you say, some people say, well, let me put my daughter on the house. Well, if your daughter is a Florida resident and she already has her homestead, then you might lose half of your homestead exemption if it's jointly owned by the two of you. Or, some people don't like to put their daughter on the house because they're afraid that she might get divorced or she might, hit Betty's car while it's parked and, have some liability. And they're like, well, I don't want my home protected. So you don't want to put the child on necessarily. So then the next step.
What is a ladybird trust? A ladybird deed?
A ladybird deed is a type of deed that passes property outside of probate. It's a nickname. It's a nickname, and I don't know where it came from, whether it came from Lady Bird Johnson. Yeah, it did. Anyway, but the real name is it's called an enhanced life estate deed. So, because the next step after just putting somebody on as joint property is to say, well, I'm going to retain a life estate in my house with full rights to live in it, and I'm going to give it to my son upon my death. But the problem in that case is if you decide, oh, I want to sell this house and buy a townhome, or I want to move to a retirement place, the title company is going to tell you, oh, wait a minute, we need to get Junior to sign off on that deed too. And a lot of people that have spent their life, accumulating their own property and being independent don't like the concept of having to ask their children to sign off on these things. So that's what the enhancement is. Basically, when you retain the life estate, you retain full control to sell, rent, all that property during their lifetime. So it basically turns it into almost a payable on death account, but for real estate. So I think there's 5 or 6 states that have ladybird deeds. It's not everywhere. But most of the other states that don't have the concept of an enhanced life estate have passed a law that allows for, they call it a TOD, deed, transfer on death deed. Anyway, which does the same thing as a ladybird deed. So let's see here. The other thing is, you know, we do, the basic, I think, assumption is that probate is a bad thing because of the expense and the time in the court. But some people have families that really can only be dealt with by having it supervised by a judge. And they can, you know, they can say, well, we're going to do that, we're going to set up a trust, but strangely enough, because of their kids, they end up in court anyway because they don't get along. So anyway, so, you know, sometimes you know, oh, you know, this person is, it maybe is better that there's a judge that has to sign off on all this stuff because I can't trust if my son is the successor trustee and he's doing this all on his own and nobody's really watching it, he could take more than he was supposed to and, you know, not treat his siblings right. So, and some people, you know, some people have families that get along, some people have families that don't, and there seem to be a lot of those. So, anyway, so that's your will. That's your will. The other thing is you can put in your will other things, extraneous things, like, you know, burial instructions. I want to be cremated with my ashes scattered over the Gulf of Mexico. I want to be buried in my family plot, that sort of thing. So you can put things like that. And then every will has an appointment of the personal representative. So that can be the same people that you're giving the money to, the beneficiaries. I mean, your standard will is you always have your, you know, everything goes to your spouse first. The spouse is the personal representative. And then upon the spouse's death, then it may go to your children if you have any. They may be the personal representatives themselves if they don't get along or if they're too young or whatever, you may choose other people. But did you have a question?
Yeah, I just became a resident last month here
Uh-huh.
in Florida. I moved from Pennsylvania, and I had all my legal documentation done in Pennsylvania.
Uh-huh.
So do I need to get anything?
Not necessarily.
Okay.
The full faith and credit of the U.S. Constitution says that if you were a legitimate Pennsylvania resident when you did this, it's still, Florida has to take your will. I mean, it's still okay. I mean, it's always a good idea to have somebody look at it to see if there's anything that is special in Florida law, but no. You know, Florida's actually easier on witness. So some states require 3 witnesses. We only require 2. So if for some reason you came from a state that only had 1, and they'd say, that's not a valid will in Florida. Well, if you were a Pennsylvania resident at the time and it was a valid will under Pennsylvania law, they take it.
And then would that be the same for, say, a durable
No,
POA?
no, that is the durable power of attorney, the living will, healthcare surrogate, stuff like that. Those are real statutorily based. So yes, they will accept it if you were legitimately Pennsylvania. But I always suggest that you at least get a power of attorney, the living will, and the healthcare surrogate done, because those things are all very statutory to the particular state. So, although every state seems to have them. Yes.
My wife and I are residents of Massachusetts.
Uh-huh.
If I die in
I-
fire,
I am going to get to that.
what I have her do is dump the body in the back of the car and take it home, because my executor is in Massachusetts, my trust owner is in Massachusetts.
Uh-huh.
That is,
Well, we will talk about part-time residents and whatever. I'm going to get to that about where they do the estate and whatever. And I'm not sure that you really want to have it in the trunk traveling across state lines. You don't have to do that because it works out okay. But anyway, we'll talk about that. So the other thing is the power of attorney. You know, a durable power of attorney. Durable means it survives your incapacity. All powers of attorney are durable. I don't know why they always refer to that. So anyway, a power of attorney appoints somebody to act on your behalf while you're living. The power of attorney expires when the principal does, the person that gave it. So once they're sort of parallel, a will and a power of attorney. Once the person dies, you can't use the power of attorney anymore, and you have to go to the will. And before the person dies, you can't use the will, you have to use the power of attorney. So anyway, the most important thing you can take away about the power of attorney here is that since 2011, you don't necessarily have to be incapacitated for somebody to use the power of attorney. There used to be a thing called a springing power of attorney where you appoint somebody and you had to have the doctor say that you were unable to handle your own affairs. They decided that that was too difficult for the clerk at the Bank of America to figure out. So they got rid of that. And so basically, once you sign a power of attorney and hand it to that person, they can use it, even if you're fine. So that's why you only want to sign a power of attorney to somebody that you really trust, because it's like a loaded gun, okay? Or you can use your attorney as a custodian to sort of be a gatekeeper for that, which is you don't hand that power of attorney over to your person. You say, you can find that in the back desk drawer if you're not too concerned with them getting in your house, or my attorney has that, and if you call him up, he'll ask to make sure that the doctor says that you can't act or whatever, and then they'll give the power of attorney out. So the most important thing is just don't go willy-nilly giving powers of attorney to people that you don't know or trust really well. Because once delivered and signed, they can use it. And I did have a situation with a lady who appointed her niece. In Florida, there are a lot of people that come from other states, and there are a lot of people that don't have close family and children. And so this person appointed her niece from Ohio to be her power of attorney, which sounded good. The niece was down for spring break. She, did what a lot of people might do, and it's like, here, I want you to have all my documents. And a couple weeks later, when the niece was back in Ohio, she found out that she had written a check for her rent out of her aunt's money. So, you don't want to, you got to be careful with the power of attorney.
If you're a Florida resident, does your power of attorney or your executor have to be a Florida resident?
Power of attorney, no. Executor, yes. So it is kind of weird along that spectrum. The only thing that there's an actual statute that says that they have to be a resident of Florida is for a personal representative of an estate. But there is an exemption if they are a family member. So if your daughter lived in Ohio, she could be a personal representative. But if your best friend lived in Ohio, they can't be a personal representative.
What about a sibling?
Sibling, yeah.
How about a son-in-law?
I'd have to check on that. I think they could, because on the list of who can do it, it's like ascendants, descendants, siblings, and I think there's a place for the spouse of one of those people. So anyway, but there's no corresponding rule for trustees, powers of attorney, healthcare surrogates. Don't know why. It's probably unconstitutional, but anyway, to do that.
But for the executor, there's an exemption for a sibling if they're not.
Yeah, family member. Yeah. Did you have a question in the back? Did you have a question in the back? I have a question. Oh. Well, let's finish up on the power of attorney, and we'll get there, and then maybe we can ask that. Okay, so that's primarily a financial document, and just remember that there are certain powers, like the right to make gifts, the right to, certain things that you actually have to have a separate initial on. Those are called the superpowers. Superpowers. So anyway, and on all these things, you can have more than one person designated as that fiduciary, either in sequence or together. I mean, it's allowed. So you can appoint both your kids to be your healthcare surrogate, or you can appoint one to act, and if one can't act, then the other. And there'll be more about that, because I just have a quick little thing about it that I saw in a publication that they think that's a really bad idea. Because, you have to decide, obviously, if there are 3 kids spread across the country, it's going to be a little bit of a logistic problem, and also they may not agree. Should we sell mom's house? No, we'd like to keep that house. The market will get better. Let's dump it. Things like that. So it's better to set up a dictatorship than it is a democracy. So you want one person to do it so they can cram it down the throats of their siblings. But the problem is, of course, it creates animosity. If the bossy sister is the personal representative and she decides everything, her siblings are not going to be very happy. But if all the siblings are named, it may be more palatable to them, but they may not get anything done. So it just depends on how you feel about that. So, during lifetime for the financial side, the power of attorney, on the health, there's a parallel healthcare side that is a living will healthcare designation of healthcare surrogate. So that's the one that, a living will is a document, which unfortunately is called a living will because it has nothing to do with your property, and it's very confusing to people to call it a will. But it's an expression of intent that says, if I'm in a persistent vegetative state, which is a coma or a terminal condition with no likelihood of recovery, I don't want to be kept alive artificially. And there's a definition of what these extraordinary measures or heroic measures are. Yes?
Do you require a lawyer for a living will?
No. No, there's a number of forms out there. I think that was one of the questions that was asked here, and I'll try to, let's whip through this, and I'll try to get to the things that you really want to hear. So the appointment of healthcare surrogate is like a power of attorney to make medical decisions for you. So you'll have that. Yes?
Okay, question.
Well, as I just said, you do not want a plain power of attorney. The durable word means that it survives your incapacity, and I would say 99.99% of people that sign a power of attorney want it to be used if they become incapacitated, so they're all durable. The only time you have a regular power of attorney is sometimes you may be out of town, you may be in your summer residence in Cape Cod, and you want to sell your house, and so you appoint somebody to sign all the papers. That wouldn't be a durable power of attorney. That's a specific one. Yeah. Anyway, so there's some secondary documents on the healthcare side. People may have heard of a do not resuscitate order. A do not resuscitate order is a living will, like on steroids. A living will, you can have a living will, but if the paramedics come to your house and they find you there, they will revive you, take you to the hospital, and then say, oh, he has a living will, he doesn't want to be kept alive, so they'll pull the plug. So the do not resuscitate order is designed so that they don't even resuscitate you. But it requires another step. Your attorney or yourself doesn't do it themselves. They have to take it to your physician who signs off on it. And it's on canary yellow paper, and you're supposed to stick it on your refrigerator because that's where paramedics are told to look, you know. And you can also do it informally, which is if you don't have a do not resuscitate order, but you don't want that, I've heard where people, they just don't call 911 if something like that happens. So, or tell their loved one, don't call 911. So you do have to get that signed by your doctor. And then the final piece of paper is sometimes people will want to do a declaration of anatomical gift. So where you give body parts. You can put that in your regular will too, or you can have it as a separate thing that says, you know, I want my organs donated. And you can actually be specific, and because I had somebody that asked about it, and this is okay, they don't mind organs being donated, but they did not want to be a cadaver at a medical school. So, you know, they're like, take my kidney, but don't like have amateurs cut on me for a semester. So anyway, you can put stuff like that. So anyway, let's see. The question I think that came up, somebody said before, was there are forms that are in the statute that are suggested forms, but you're not required to use one of those. You don't have to use an attorney for any of those medical things. There are a couple of them that are out there called the 5 Wishes, which is, it's a document about your medical care. It's a little bit more, you know, touchy-feely than like attorneys like to do, and it'll say, you know, keep me in a darkened room with like restful music. I do want to be, you know, covered with a washcloth, but I don't want artificial feeding, stuff like that. That's the 5 Wishes. That's a national one. You can get that online, and that's perfectly valid. Baycare, which is, you know, our largest health system. I know they have one that's out there that you can get online. That's an advanced directive. And keep in mind, the term advanced directive is the envelope term for all those individual documents. So you can go online and get those and prepare that. And for those snowbirds that are here, if you're visiting from Massachusetts, they will take your Massachusetts healthcare surrogate. You don't need to go, I'd love for you to do it, but you don't need to go to an attorney and get a Florida healthcare surrogate. So the other thing to remember, and then we'll maybe get to some questions here, is there are statutes out there that create these documents for you, even if you don't have them. So if you haven't gone to the effort of setting up what you want, it will happen for you, because it's called intestacy, which is if you don't have a will, they have a list of people that they assume will be your beneficiaries. So it'll say if you're married and you have no children, then it all goes to the spouse. If you're married and you have children, all of the children whom are children of the surviving spouse, then it goes to the surviving spouse. So that's like your nuclear family. It would go to mom in all those cases. If you are survived by a spouse and children, but some of those children are the spouse's children, or some of them are just your children and not the spouse's, then it's 50% to your spouse, 50% to your children. And then they have a whole thing that says if you don't have any of those, no children, no spouse, then basically it goes up the line to your parents. At that point, most people don't have living parents. So then it goes down the line, so it goes to your siblings and nieces and nephews. If you don't have any of those, it goes up one more to grandparents, which you probably don't, but it gets down to like cousins and first cousins and stuff like that. And, yeah?
If you're distributing your brokerage account to charities, is it better to have the brokerage distributed or at the executor?
That's a good question. It's easier if you designate, if you have a limited number of charities, sometimes people will designate them in the account as a payable on death. But there's going to be some administration expenses in dealing with your primary residence or other property, and it's probably a better idea to have the trustee do that, make those gifts per your trust.
The brokerage can be.
Per your trust.
The brokerage.
You can do it. Yeah, you can do beneficiary designations on brokerage, including that includes a charity.
They don't take.
No, because that's exempt from any kind of tax for the most part if it's a charitable 501c3 organization. So you can do that. Yes. So anyway, so there's this intestate thing, because a lot of people have this notion in the back of their mind that if I don't have a will, it's going to go to the state. You pretty much have to have no relatives before it goes to the state. After the grandparent level and going down, there's actually a paragraph D that says if there's none of those people, if there's they go to your spouse's relatives. So are there any of those people of the last deceased spouse that you might have had? And if you are a descendant of a Holocaust survivor, they actually go up one more level to a great-grandparent before it escheats to the estate. But if you had absolutely nobody like that, it could possibly go to the estate. So there's also a default if you never have done a declaration of healthcare surrogate. It says who it will be, it's your spouse, it's your children, or whatever. And that was, of course, the basis of the famous Terry Schiavo case, which I think everybody is aware of. She obviously did not have a designation of healthcare surrogate. So they look at the statute and they said, oh, she's married, her husband gets to make the decisions. But of course, she was very involved with her parents, and her parents didn't agree with her husband. So it sort of set up a situation. If she had done a healthcare surrogate, which most 40-year-olds don't, she might have appointed her parents instead or something like that. So it's always good to think about these things, and I think it's great that this group has really embraced this with the Red Book, because you'd really rather make your choice than have it chosen for you. If you have a dysfunctional family, you may want your money to go to the SPCA instead to help the animals instead of your, brother that you hate. Or your nieces and nephews that you've never met. Wouldn't you rather go to your friends? So that's why you want to do that. And I guess I'd like to get into some of the questions.
John?
Yeah?
Could I make an announcement that we don't want to get into personal situations?
Right, okay, yeah.
You know, because we have a limited amount of time, just
Sure.
kind of.
But some of the things that Marge had asked me were, you know, and I think this has come up, was the advanced medical directives, is there only one format, and does it matter which format you use? No, all those formats are good, and the one that you feel most comfortable with is fine, and you don't have to use an attorney. Where do you need to file these medical forms? There's no central depository for any of this kind of stuff. Although there is a rule that if you have the original will of somebody you know to be deceased, you have to file it at the court within 10 days of their death. 10. There's no penalties and nobody ever does it, but, go ahead.
So I also want to make a comment that if anybody has a question, that they has a question, that they can type it into the comments.
Okay, very good. So anyway, there's no,
John, she wants to make an announcement.
So if anybody is online and wants to ask a question, please type it in to the comment section, and we'll have that read and answered for you.
so
Okay?
there's no
Thank
place
you.
to file this, but you should give a copy to your primary care physician, so it becomes part of the electronic medical record, yes?
Last week, somebody mentioned, in addition to the DNR, a most document.
Yes, so
Repeat the question.
it's a post.
Would you repeat the question so people can?
Somebody mentioned beyond a DNR and a living will, there's a thing called a post. I think it's called a post. No, I don't know what that is. There is a POLST, which is a something. I don't know. I would have to look that up. I can get back to you on that.
It depends on the state. In certain states, they're MOLST.
I think they're pulsed here, but anyway. I'd have to get back to you on that. I'm not super smart on that. So anyway, so make sure your doctor has a copy of those medical forms. The do not resuscitate, as we discussed, the doctor has to sign off on it, and there's a specific form that all your doctors will have. Do you need a lawyer to generate these forms? No. Do they need to be officially witnessed? Yes. All those documents have to be witnessed. And specifically on the power, the healthcare surrogate, the healthcare surrogate is not allowed to be one of the witnesses. But there are two other people. You know, somebody had asked about executors. What do they do? What is the relationship with the POA? I think we discussed it. They are the ones that administer your will. And the relationship to the POA is they're very often someone will name the same person to have those jobs, but they are two different hats that they take off the hat as the power of attorney when you die, and they put on the personal representative hat. And I'm sure there are people that go to the banks all the time with powers of attorney for dead people, but you shouldn't do that. And I think they make you sign an affidavit, so you could get in trouble for that. The personal representative, which is the executor, it's the person that takes over after you die, and the power of attorney is extinguished. You know, does a written will or trust have to be filed with a probate court? That was one of them. I'm not sure who came up with this one. Does the designated person have to report to the probate court periodically or to close the estate? The person who's acting as the executor or the personal representative has reporting requirements of posting the inventory, dealing with the creditors, and then they do have to file this thing called a petition for discharge to get it closed. We haven't talked much about children and guardians, but if you have minor children, it's always better for you to pick a guardian than to have the court choose a guardian for you. So what happens if no guardian is named for a children? They always use the term, it's the same term they use in family law, which is the best interest of the child. They will always try to find a family member that does it. But if your one brother is a horrible drunk, court's probably not going to appoint them. It's possible that they would appoint a either further away relative or even a non-relative. We talked about what happens if there's no living will or advanced medical directive. There is a statute that says what happens. The next one, what happens if there's no POA or executor? Now, we did say that the intestate statute says where your money goes, and it says who of your relatives is entitled to priority. But there is no default or backup power of attorney. So if you don't have a power of attorney and you become incapacitated, but you're not deceased, you will be going into a guardianship where somebody is appointed as your guardian for your person, meaning making choices for you, or your property, by the court. So usually it's a family member that says, you know, Aunt Gladys is messing up here. She's falling for every scam. You know, we need to do something. And they're professional guardian. A family member can be a guardian. They have to go to school. There's a class at SPC that they take. But the court does prefer professional guardians because they work smoothly. Although many of you probably saw that movie on Netflix, I Care a Lot. So did anybody see that? It was a movie about the evil guardian that she colluded with the judges and took over these people's lives. But anyway, we like to think that doesn't happen too much, but it was really scary.
There's a question online.
Okay.
Someone said their will was done 4 years ago by an attorney in Hillsborough County. They live in Pinellas.
Well,
you know if their current will needs to be redone by an attorney in Pinellas.
right, no. So Florida's a unit, so it doesn't, I mean, anybody that's licensed, a licensed attorney in Florida can practice anywhere in Florida. So if they had one done in Hillsborough, there's no need for that. One of the things I'd like to mention, and I guess I am remiss in not mentioning this, is a will never expires. So you can have a 30-year-old will. The problem is life changes. So that 30-year-old will is probably not what you want. You probably would rather have intestacy than that old thing. Because if you had a 10-year-old kid then, that kid is 40, so we don't need to worry about having a trust for their benefit or having a guardian. Likewise, on the other end, when you were naming your older brother as the personal representative, they may now be 89 years old and maybe not the best choice for that. So a will, tell the people, or I guess I'm telling you right here. Sorry about that. The will never expires. It's always a good idea. You know, I'd say every 5 to 7 years to find out if, you know, new children have been born, people have passed away, people have gotten married, people have gotten divorced. You know, sometimes people will have it where they leave stuff to their son. If he doesn't survive me, then to my daughter-in-law, whatever. The daughter-in-law is not there. She doesn't want to leave it that way. So, yes?
What papers should we put in our red book? Papers should we put in our red book? And do they need to be original?
So that's interesting, because I always give these people these little like envelopes with the original. Oh, what should go in the red book? Should they be originals or copies? I would think the whole point of the red book, though, is where somebody can find all that stuff easily, and so I'd probably have the originals. I might have given some of those originals to, like I said, a physician, like your living will and your healthcare surrogate. My practice is they may want to see the originally signed document, but they do not need to keep the original. They're going to scan it or make a copy and give you that original back. So if you change your doctor or whatever, you have that. The most important thing, which I haven't discussed either, is where do you keep all this stuff? So this red book is actually a very good idea because the first idea is let's put all this stuff in the safe deposit box. But if you put it in the safe deposit box, you have to worry about who can get access. You have to put somebody else on the signature card or they can't get in there. And then even if they're on the signature card, they may not be able to get there on a Saturday night or whatever. So it's generally better to keep, you may say, well, I want to put it in a safe. That's fine, but it's better to probably keep those things at home. The red book is a nice idea. I haven't run across that before, but I like this concept because it sort of stands out and you can it's an easy instruction to your kids in California, that I have a red book in the back bedroom that has all that stuff. So I would say keep the originals. I mean, if you put 3 pull binder holes in your will, it doesn't invalidate it. So you could still file it. Yes.
So I was just gonna say, someone said if you put holes in a desk, you could put holes in a desk.
I've never had that happen, but, yeah. Oh, do holes in a death certificate mess it up? Well, I've never had that happen. You can always order another death certificate anyway. It's weird, they have these little gold squares all over them. I don't know if you've ever looked at a death certificate recently. That's so you can't make a copy of it. When you make a copy, it has void, 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 void all over it. So, but you can always, up to about 2 years, you can actually, for about 6 months, you can get it from the funeral home. So they can get a copy. Up to about 2 years, you can get it from the local Department of Health, which is on East Bay Drive. And then after that, you have to get it from Jacksonville. So you can always get another one. Oh, yes, sir.
Couldn't the executor have the original will?
No.
Why?
I mean, if you have a very standard will that leaves everything to a spouse and then to your kids, it's fine, but you may change your mind. You're allowed to.
Will and trust department, and trust documents, all of those.
Uh-huh.
The executor in our case is a trust officer.
Oh, okay, then that's fine. That's fine. It's just, a last will and testament says the word last will and testament, but we don't actually know what your last will and testament is until you actually die, because you could change it every other year or whatever. So sometimes you create expectations, particularly if it's not family members, that, oh, here's my will and it leaves you 30%. Well, you get mad at that person and you do a new will. All of a sudden, when you die, they're showing up with that will. The court will only take the latest date one, so it's not a problem, but you've created expectations and you have to get that back. Now, you've used a trust department, and so that's a professional that is trained to handle that stuff. So yes, they should. In that case, they should have the original, because then they're not gonna have to call your daughter and find out where you kept your original. But you're gonna have to remember if you've made any substantial changes, but actually, they're acting as the executor, right, or the trustee? The trust department? They're acting as the executor after? Yes. Yeah, so they're gonna have to sign off on any changes to the trust or the will anyway. So in that case, yeah, that's actually a preferable thing to do.
Another question online.
Uh-oh, okay.
Someone asked, have you heard of freewill.com and is it legitimate?
I have heard of it, but I don't know if it is. I mean, there is no requirement that you do a will with an attorney. It just has to be witnessed by 2 witnesses at the bottom. And it has to be, they call them holographic wills, handwritten wills. So Florida doesn't allow holographic wills, but they define a handwritten will. But they define, but you can have, as long as it's properly witnessed and signed to the bottom and witnessed by 2 people, you can actually handwrite it. That's not a holographic will. So I guess it's okay, there's no reason why you couldn't use that. I'm not familiar with their exact process. Yes, ma'am?
Can I find out the answer online if my son-in-law, who lives in Ohio, can be my personal representative?
Oh, well, I'll tell you before you go. Yeah, I look, I'm almost positive that he is. I'm almost positive that he is. Yes, sir?
So your will is in your possession? So your will is in your possession?
Not until you die.
Courthouse?
Yeah, not until you die. Some states, I understand that some states have where you can deposit a will. But it's the same thing that I discussed with that gentleman, is if you deposit that will with the court, you probably need to get it back if you're making changes. It's just another thing to remember if you update or make changes to your will. I think the thing I've written down and I forgot to say, and I do want to mention to some of the people that are snowbirds in the audience, is your estate and trust administration is generally done in the state of your domicile, whatever you consider to be your official residence. So, if you're a Massachusetts resident and you just happen to die down here in Florida, they can get you back home, not in the trunk, but in some legitimate form of conveyance, and it will all be it'll all be administered in Massachusetts. Now, and if you have even if you had a bank account at this Bank of America here or whatever, that's intangible property, and that would be administered per your domicile. The only exception to that is if you own real estate in another state, that's considered to be so closely tied to the state where it's located that you might have to do some sort of secondary administration, which they call an ancillary administration, where that house is. So you might have your primary administration in Massachusetts, but they might have to open up something here if you own the house. So that's why it's better to have it joint or in your trust, because if in your trust, it's not a probate asset and you don't have to do anything here. Yes, ma'am.
I have a question.
Uh-huh.
As far as cars, as far as, those are usually then a single person's name.
It's okay. Cars are, so the Department of Motor Vehicles, or actually, in Florida, it's actually the tax collector that administers it for the DMHS, Department of Highway Safety and Motor Vehicles. Joint, obviously, you don't have to worry about, but for the most part, they will let you, just with a copy of the will, transfer the car. It's usually not a problem. So you can usually go in with a copy of your will and the death certificate and say, Dad left everything to me, and they'll usually, if that's the only thing, if you have an estate that's open, you'll show up with your estate administration. But if everything else was joint and you just have this car, I've found that you just show up with the death certificate and the will, and they will transfer the car to you, because that's generally exempt from claims of creditors anyway, at least one vehicle. So, yes, ma'am? At least one vehicle. Yes, ma'am?
If you have a will, an executor, and an attorney, and you file an inventory with the court, is that the way to?
No. No. If you have a will, if the will is your only document that transfers it, that's not going to do it. You have to have a trust or a payable on death type thing. So the inventory is what you have now. You would make a list of what you have now? Make a list of what you have now? Right. But if it's in the will, it's still going to have to be administered. But a lot of times when people...
By the executor, not the court.
Well, the executor is the one that does all the work, that transfers it, but they don't have any authority until the court appoints them, or whatever you want to call it. So you do have to file a petition with the court. Yikes. The judge is not going to be, the judge isn't going to go to Wells Fargo Bank and transfer the assets. It is going to be your executor that does that. But the executor, Wells Fargo is not going to do anything for your executor unless they show up with that magic certificate that was signed by the court. Oh, I didn't even know that. Sorry. Okay.
The purpose of filing with the court after the distribution is taxes?
After the distribution?
Well, why is the court involved if your executor is doing the work?
Because your executor has no authority. This is why I do it. This thing. Your executor has no. I keep tripping on the cord. The executor has no authority without being named by the court. Once they're named, they do it on their own. They don't have any authority. It's like getting a driver's license. I mean, your executor can drive the car, and if they get pulled over, they're going to get stopped unless they have a license, and they had to go to the DMV to get the license. I don't know. They have to be appointed before they don't have any authority until they get appointed. But a trustee...
Then there's no probate.
No, it is probate. Probate is the appointment. It goes from when they get appointed until they go back to the court and say, I've done everything, I've paid all our taxes, I've transferred all our assets, I've got receipts from all the beneficiaries, please discharge me. So, yeah, but we can talk. Yes.
If everything you have has a beneficiary attached to it, has a beneficiary attached to it, do those assets immediately go to the beneficiary?
No, it immediately goes to the beneficiary. So if your bank account has a beneficiary on it, all they have to do is show up with the death certificate. And
the car, you said, if that's the only thing that doesn't have a beneficiary on it.
Right. Then show up with the death certificate and the will and get that done. So they're probably, the problem, I mean, that's a great way to handle everything is to have it all POD. But the problem is there's probably going to be some sort of things that take money to keep going. And so the question is, how does that? So if you've got all your liquid assets are payable on death to somebody, but your house you left to somebody, then, right, so ideally then, in that case, I guess the Lady Bird, they show that they own it, and whatever expenses are still sticking around, if you hadn't paid the taxes the year before you died, they're just stuck with them, probably is how. Right, but if you have a lady, so if you had everything done payable on death and nothing else as a backup for payment, who's paying the expenses for the electric or whatever? But if you have a Lady Bird deed, it's clear that the second you died, that property passed to that beneficiary, so the beneficiary is stuck paying for those until they sell it. Because they're gonna get the proceeds. Yes, ma'am? Because they're gonna get the proceeds. Yes, ma'am? Right. It would still, if you're considered a Florida resident, you should, your documents should be Florida documents and it would be administered here. Do you own a property there? Yes. Okay, so I don't know what you do in that. Is it in the name of a trust or just your name?
No, it's not in a trust, joint ownership.
Okay, well, hopefully if you're survived by a spouse, it's not an issue.
She's gonna put me in the trunk of the car and drive me back.
Yeah, but just like him, though, you don't need to do that because it's clear that it would all be governed by Florida, But the problem, the other thing is there's a treaty between Canada and the U.S., so it's good. You only get taxed in one place and that sort of thing, so it shouldn't be a real problem. It shouldn't be a real problem. Well, I told you, in states they do because of the full faith and credit of the U.S. Constitution. That's wide open for Canada. I would think they would if you had some sort of document like that because there's so much cross-border stuff. But I check with somebody there because they may have a different system. Canada's different. I don't want to call it weird because we're probably the weird ones, but they don't have an estate tax. They basically have an income tax when you die. So like when you die, they basically treat it as, they deem it as if you sold everything and you just pay capital gains on all your stuff. So it's not quite parallel, but they do have a treaty that makes it so you don't get caught twice. So, okay. Oh, well, let's do one more there. And then we'll get out.
I just looked up most, and most is medical orders for life-sustaining treatment. And post.
Oh, okay. Well, that's good. I've only heard the term post. I've been to like, seminars and stuff like that. So anyway, so I appreciate your staying awake and paying attention for all of this. So anyway, thank you for being receptive. And I will find out your Ohio thing.
Well, this completes our seminar for today, and thank you everyone for coming. And John said he would stick around a little while if anyone has any questions for him. Thank you.